Good afternoon, everyone, and thank you for taking the time to view this video. We'll be covering Plex vs. Felt case pretrial overview featuring myself, Helena Gray, Zane Fasal, Gage Moore, and Franklin Serble for CS306. We'll go over cause of action, legal elements, as well as relevant cases. To begin, we'll define what exactly defamation means. In 28 U.S. Code Section 4101, defamation is defined as any action or other proceeding for defamation, libel, slander, or similar claim alleging that forms of speech are false, so basically lies, have caused damage to reputation or emotional distress. Damages can also be monetary in nature, which will be covered later, have presented the subject in a false light. Now this sounds really similar to the first bullet point, but it actually just means any misleading implication or insinuation that a normal person would find offensive. And finally, resulted in criticism, dishonor, or condemnation of the subject. Now to prove defamation, a few things are needed. Firstly, a false and defamatory statement concerning another. Now let's break this down. A false statement was decided upon in Chapin, or what exactly constitutes a false statement was decided upon in Chapin versus Knight Ritter, Inc. 993. What's considered defamatory in nature was also defined in this same case, and is quoted as harming the reputation of another so as to lower him in the estimation of the community, or deters third persons from associating or dealing with him, or makes the plaintiff appear odious, infamous, or ridiculous. And finally, what constitutes as being about the plaintiff was decided upon in New York Times Company versus Sullivan, 376 U.S. 254. The unprivileged publication of the statement to a third party is also needed to be shown. And third party is basically any other entity that's not the person defamed by the statement. And in this definition, person also includes corporate entities, not just individuals. So what exactly is an unprivileged statement will be covered later. Made to a third party was defined in Montgomery Ward and Company versus Nance 165 VA 363. Thirdly, if the defamatory nature is of public concern, fault amounting to at least negligence on the part of the publisher needs to be shown. And what exactly is negligence and public concern will be covered later. And finally, damage to the plaintiff needs to be shown. And like I said before, damage can also be monetary in nature, not just reputational.
Number 1, what is a false and defamatory statement concerning another? This means that the statement said by a client must be false and must be defamatory in nature. It's false, it's an untrue statement. Pure opinion is covered under Virginia Constitution. According to the Virginia Constitution, the statement that is claimed to be defamatory cannot be pure opinion, as it is covered under Article 1, Section 12 of the Virginia Constitution. Lastly, concerning another is the subject must be identifiable to a legally significant group, even if not explicitly named. Again, the false statement must be made based on fact, not mere opinion. Number 2, what is the unprivileged publication of the statement to a third party? If the statement is made under certain contexts, such as in legal proceedings, then the statement is said to be privileged. One cannot sue someone for defamation over a privileged statement. And 2, for publication, defamation and libel are not treated separately. Whether the statement was verbal or in writing, it's important that a third party heard it and understood it was about you. Number 3, what is if the defamatory matter is a public concern, fault amounting at least to negligence on the part of the publisher? Well, matter is considered to be a public concern if it is social or political in nature and of interest to the public in general. What does that mean? A matter is a public concern if it satisfies one of the following: the statement related to any matter of political, social, or other concern to the community. 2, the statement related to a subject of legitimate news interest, that is, a subject of general interest and of value and concern to the public. And Lastly, negligence can occur if publication contains any information that contains errors or fails to disclose possible consequences of acting on such information. So, what does that mean? For example, negligence on the part of the publisher occurs if the publication contains instructions, advice, or other information that contains errors or defects or fails to warn the reader of inherent dangers. And the reader, by using or acting upon such instructions, advice, or other information, dies or damages his property. To prove negligence, one of the following must be proved. One, the publisher owed a duty of care to the plaintiff, and that duty of care was breached by the publisher. Two, the plaintiff's injuries would not have occurred except for the publication of the publisher's publication. Or three, the publisher could reasonably have foreseen the likelihood of harm to the reader. Again, to prove negligence, one of the following must be shown: breach of duty of care, cause of injury, foreseeable harm. Number four, what is considered damage to the plaintiff? This simply means that some sort of damage must have happened to the plaintiff. Typically falls into two categories: special damages and pain and suffering. Special damages can be calculated to the dollar, including lost earnings, future lost capacity, and lost business or economic opportunities. Pain and suffering means not just mental pain and suffering, but also impairment to reputation and standing in the community, personal, sorry, and standing in the community, personal humiliation, shame, and disgrace. Again, to recap, this is two categories: special damage and pain and suffering. To do special damages, it has to be lost earnings, future lost earning capacity, other lost economic opportunities. For pain and suffering, it has to involve impairment to reputation or simply put, personal humiliation.
The two most important cases related to the legal elements is the New York Times versus Sullivan and the Curtis Publishing Company versus Butts. The New York Times Company versus Sullivan established that if the plaintiff is a public official, actual malice must be proven, and we will get into exactly what actual malice is in the next slides. The Curtis Publishing Company versus Butts, that extended this actual malice must be proven to also cover public figures. In the New York Times Company versus Sullivan, this case, there was a public safety commissioner named L.B. Sullivan. He was suing the New York Times for publishing an ad from supporters of the Martin Luther King movement. This ad contained several inaccuracies, and ultimately the court didn't want people to sue organizations and drive them out of business. So what the court established was a higher burden of proof, and this is what they found was actual malice. This higher burden of proof must be proved in order for the plaintiff to win. So this gets into what exactly actual malice is. Actual malice is when someone communicates, publishes a false statement with knowledge of it being false, or is reckless that there is a blatant disregard for the truth. So they don't necessarily have to know that it was true or if it was false. There just has to be a blatant disregard for whether it is. And this also leads us into what exactly is a public official. Well, a public official is defined under the cases as you can see here: Hatfield versus New York Times, Gertz versus Robert Welch Incorporated, and the Rosenblatt versus Bayer. In order to be a public official, this has to be someone of the hierarchy of government employees. They have to or appear to have substantial responsibility for or control over the conduct of government affairs, and their position in government has such an apparent importance that the public has an independent interest in the qualifications and performance of the person who holds it. So think about this could be, the president, a governor, police commissioner. They can take on various forms, but essentially they have to have this hierarchy of government employees in order to be a public official. So the Curtis Publishing Co. versus Butts, this court ruled that not only can public officials sue for defamation, but also public figures, and actual malice must be proven for all public figures as well. In this case, an article was posted in a Sunday Evening Post that alleged a University of Georgia coach threw a game in coordination with another coach. Since he wasn't quite a public official, but a public figure, Butts won the case because there was an inaccuracy in the article that was published. Since the source was a very shady source, there was a highly unreasonable conduct done by the Curtis Publishing Company. So in that case, Butts ended up winning because he was a public figure.
All right, let's talk about public figures. Now, you may be asking, what is a public figure? And I'm here to tell you, as you can see right on this slide. A public figure is a person who has a certain social position and is often of concern to the public. Think of a public figure as either a CEO or a politician or a celebrity or social media personality or business leader, etc., etc. Their social position and their influence of society means that what they do is of concern to the public, and what they do is closely related to the public interest in society. Now, it's not that simple because there's actually types of public figures, which are separate from private individuals like you and me. The first type of public figure is as defined in Carter v. Forbes, is a limited purpose public figure. And in order to be classified as a limited purpose public figure, you have to fit all 5 criteria. First, the plaintiff must have had access to channels of effective communication. And 2, they must have voluntarily assumed a role of special prominence in the controversy. That is important because he has to show that they directly participated in this event and that they were trying to show their side of the story. 3, seek to influence the resolution of controversy. And 4, the controversy had existed prior to the publication of defamatory statements. If the controversy only existed because the defamatory statement got published, then that person is not a limited purpose public figure. And 5, the plaintiff retained public figure status at the time of the alleged defamation. Perhaps number 4 might be true, that there was a controversy, but then the controversy died down and then a defamation statement happened. Then, in that case, number 5 would probably not hold true because the plaintiff would not have retained that public figure status. An example of this is Hatfield v. New York Times, where a scientist had sued New York Times because there was an article in it alleging that the scientist was responsible for committing anthrax attacks that had happened in New York City. The scientist had claimed defamation, and the court looked and determined that he was a limited purpose public figure because he had fit all those 5 criteria. He had lost that case because all limited purpose public figures have to prove actual malice, which he had failed to do. The other type of public figure is an all-purpose public figure. And as you can probably tell from the name, a all-purpose public figure, or a public figure, is a public figure for all purposes. They have such pervasive fame or notoriety that she or he becomes a public figure for all purposes and in all contexts. Lastly, we want to talk about a specific, a special type of defamation called defamation per se. And this is defined in the Code of Virginia 8.01-45. There are 4 different criteria. So any one of these have to hold true in order for the plaintiff to succeed on his claim of defamation per se. The first one is that the person has been accused of moral turpitude, and if that claim were true, then he would have been indicted and punished. Moral turpitude is where someone commits a really evil act with evil intent or acted recklessly, and it's inherently deprived, it shocks the public. Examples include rape, murder, and animal fighting. Or the person could have been accused of being infected with some contagious disease, which is kind of relevant with all the COVID-19, but I digress. And if that charge were true, that would exclude the party from society. Or the person could be alleged to be unfit to perform the duties of an office or employment of profit, which is important because of profit, not a public office, because that's different, and that's allowed. And lastly, if the person, the plaintiff, is alleged has a statement against him that would prejudice a person in his or her profession or trade. Not the everyday layman, but somebody who's in his or her profession or trade. So, general overview in case you weren't paying attention, which you should have been. What will a plaintiff do? The plaintiff will try to prove that the subject is not a public figure or official. 2, the plaintiff will try to prove that the statement was factually untrue, and 3, prove that the statement was not privileged. If one is failed, that makes the plaintiff's job so much harder because they'll have to prove that actual malice happened. And they don't want to prove that actual malice happened because, or they don't want to have to prove that because it's so hard to prove that somebody was either acting really recklessly or just flat out knew that the statement was false. So number 1 is the easier route. Number 4 is a much harder route. And what the defendant will do is that prove that the statement was privileged means that it was not, you cannot sue for defamation on that statement, or prove that the statement was opinion, which, same as 1, you can't sue for defamation in that case because pure opinion is protected. 3, prove that the subject is a public official or figure, the plaintiff. And 4, if 3 is proved, prove that actual malice was not shown. All right, thank you for listening to our presentation. Like, subscribe, and share.